Now we will look at misrepresentation under Section 18. Now, the claimant seeking misrepresentation may resort to a claim under Section 18. Similarly to fraud, the contract is voidable, which means they have a choice. Either make the contract void or they proceed and affirm the contract and proceed with remedies like damages and specific performance. Where you get specific performance, the provisions are the same as what we covered under fraud. Now, the claim action under Section 18 misrepresentation includes positive assertion, any breach of duty which, without intent to deceive, gives an advantage to the person committing it, or causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. So these are generally three different categories. Now, even though category B seemed to suggest negligence, but it's not really negligence because negligence is based on fault. Here, even though there's a breach of duty, there is a key indication that breach of duty arises without any intent to deceive. Now, travel site has explained that misrepresentation concerns a representation that is untrue. So this part is similar to fraud, that any representation uh, has to be something that is untrue. So similar to fraud, it must be made by claimant to defendant. So this part is also similar before or at the time of the contract, and the claimant relied on the representation to enter into the contract. What is the difference would be between this and fraud is that fraud has an additional requirement, which is the intention to deceive. So you look at the definition here, it doesn't look at intention to deceive as an element. So any kind of false statement made without the intention to deceive would fall under Section 18. Now, in order to prove misrepresentation, a person must bring the case within one of the three circumstances provided in Section 18. So, if the misrepresentation has elements of fraud, 18 would not apply. So, if a person were to bring, let's say, a claimant were to bring a case under 18, the defendant's counter argument would be to allege that there is fraud. And if the claimant brings an action under Section 17, then the claimant's argument would be to say that it's an innocent mistake or that they have committed negligence. So, in most cases, when a claimant takes an action for misrepresentation, it will be for Section 18 and Section 17, so that this would eliminate any most counter argument by the defendant. While the standard of proof is also on the balance of probability, take note that even for fraud, this has changed. So it's no longer beyond reasonable doubt. It is also balance of probabilities. Now, the basis of the action under Section 18 is whether misrepresentation could be discovered by ordinary diligence. So ordinary diligence is another reflection of the caveat emptor rule. So basically the buyer has to take reasonable steps to make sure what the seller is saying is true or false. So if there is a way to discover the misrepresentation by ordinary diligence, then there is no case for misrepresentation. So what we understand from this is that it's not only an issue of whether the claimant made a misrepresentation or not. It is also an issue of what the buyer has done. What has the buyer done to make sure? statements made by the seller is true. And it's not so much of whether the buyer did it or not. It is whether he could have done it, whether it was possible for him to do it. And if it was possible for him to have found out the misrepresentation, but he didn't, then there is no claim for misrepresentation. Now, where in the case of where the contract is signed, it is also difficult to raise misrepresentation in light of Lee, Strange and Gracop. If you don't remember this case, I would recommend you to go back to the lecture on exclusion clause and terms so that you can look at what revisit or refresh your memory on what principle the case mentions. So if the presumption in Lea, Strange and Gracop applies, then it is presumed that the claimant would have discovered the misrepresentation. Why? Because we presume that the claimant has read the contract. So if the claimant has read the contract, then he would have discovered the misrepresentation. The fact the claimant didn't read is not relevant. In SEALDAC, the plaintiff could not overcome an express term in the agreement that the land could only use for residential purposes. The reason is because here the claimant had signed the contract, and the fact that there was a term in the contract bound the claimant to its consequences. Now, the only exception to ordinary diligence is to argue that it would have taken extraordinary diligence in order to determine the misrepresentation. Now, extraordinary diligence means that the misrep is hidden. That's the first thing. And the second thing is that no reasonable steps could have revealed it. So in this sense, you got to look at the case of Gemma Kota, look at the facts of Gemma Kota, and you should be able to see that in that particular case, the misrep was so well hidden that no reasonable steps could have revealed it. So no amount of ordinary diligence would have helped discover the misrepresentation. Now, a case for misrepresentation must be based on innocent misrepresentation. This is mostly historical. So just read through the part of the slides that that explain on the historical reasons why it is based on innocent misrepresentation rather than anything else. Now we look at Admiral Cove. The explanation of innocent misrepresentation is that it is a false statement. It is similar to making an honest mistake, and it is made with reasonable grounds for believing it is true. So if you compare Admiral Cove with the previous case of that explained what is misrepresentation when we started off this particular subtopic, you'll find that there is a bit of a difference. That here the focus is honest mistake. Yeah, but that case probably takes a much more wider, casts a much wider net in terms of what means to be misrepresentation. Now, to prove misrepresentation, there must be reliance, similar to fraud. Reliance must be shown. So the question is the claimant relying on the defendant's statement, or is the claimant relying on a second opinion other than the defendant? So if the answer is that they relied on a second opinion, then there is no reliance. Yeah. So reliance is also causative. So that's another thing that you need to keep in mind. Reliance is causative, that the contract must be entered into because the claimant relied on the defendant's statement. So of course the burden is on the claimant to show this. The case of travel site, if you look at the facts of that particular case, it would explain the causative aspect of reliance. So types of misrepresentation, as I mentioned earlier, so we're coming back to the different categories. We'll go through each category to get some understanding of how it works. Now, if you look at section 18A, 18A's focus is that it has to be a positive assertion in a manner not warranted by the information of the person making it of that which is not true. Okay, so there are three aspects. Number one, there must be a positive statement. Number two, in layman's term, the statement does not add up. Third is the maker believes it. And this is where the honest mistake aspect comes in. Yeah. So the statement itself is not logical. It may defy common sense. But the maker believes it so much that he or she persuades you that the statement is true. So that is the essence of 18A. The essence of 18B is that any breach of duty. So of course here we are looking at the existence of a duty. So if there are no existing duty, then you can proceed. If there is existing duty, you can proceed. If there isn't existing duty, then case fails. So if there is a duty, then number one, no intent to deceive, because if there is intent to deceive, then it will be fraud. It must give some form of advantage to the person committing it. So advantage in terms of payment or any other form of advantage. It must mislead to the detriment of the other person or to the detriment of anyone claiming under him. So as we saw earlier, there must be a duty, must reflect a breach. The person who makes the statement gains an advantage. There is no intention to deceive, and the person who is relying on the statement must suffer some form of detriment. So if they don't suffer any detriment, I suppose there wouldn't be much of a claim. A case to consider is Lau Kon Fat. Here the court held that the defendants were liable because it appeared that the defendants had a duty to disclose information which affected the claimant's decision to enter into the contract. 18C is causing another person to make a mistake as to the substance of the thing which is the subject of the agreement. So the key is determining what is the substance of the thing which is the subject of the agreement. So here we are looking at two things. Number one, of course, the subject matter of the contract, whether it is goods, whether it is services, whether it's a thing, an intangible, the subject matter of the contract, or it could be conditions of the contract, how these conditions apply or don't apply. Yeah. So if these are shown that the statement causes one to make a mistake, so substance, then you can claim under 18C.